Good morning. My name is John Harbin. I'm a partner with King and Spalding in the Atlanta office. I'm going to be presenting for Pro Bono Partnership of Atlanta this morning on the do's and don'ts of contracting. The mission of Pro Bono Partnership of Atlanta is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. This next slide shows the requirements to be a client of Pro Bono Partnership of Atlanta, beginning with being a 501c3 nonprofit, and the other requirements are shown. You can also visit us on the website at www.pbpatl.org. We host free monthly webinars on legal topics for nonprofits. To view upcoming webinars or workshops, visit the workshops page on our website. And you can join our mailing list by using the email shown here, rla@pbpatl.org. This webinar presents general guidelines for Georgia nonprofit organizations and should not be construed as legal advice. You should always consult an attorney to address your particular situation. And all rights are reserved. No further use, copying, dissemination, distribution, or publication is permitted without the express written permission of Pro Bono Partnership of Atlanta. So as I said, we're going to be talking about the basics of contracting and some basic do's and don'ts. Beginning with the question, what is a contract? A contract is simply an agreement between two or more parties. It can be many parties to do or not to do something. We don't generally think in terms of agreements not to do something, but an example would be an employee who agrees that he or she will not solicit employees or customers when he or she leaves the current position. The requirements of a valid contract, the required elements are an offer, consideration, acceptance, and mutuality. And these are legal terms, but they basically mean there must be a specific promise offered, it must be accepted, there must be some value given or received for the promise, that's the consideration, and there must be mutual obligations. One practical point to underscore regarding the consideration of the value given is that in Georgia and most states, the court, if there's a dispute about the contract, will not generally second guess the adequacy of the value given or consideration. For example, if you contract to sell your office equipment for $5,000 and you get more information, you realize it's probably worth $15,000, the court is not going to allow you to escape the initial contract based on your unilateral sort of mistake. There's an old canard from decades, really centuries back, that we lawyers here in law school, that a single peppercorn suffices as adequate consideration for a contract. In fact, you used to see a lot of contracts that would say for $1 given and received and other unspecified consideration, the parties agreed to do A, B, or C. Another question is, do contracts have to be in writing? And the answer is, as a general rule, no. Oral agreements can be enforced. There are some exceptions by statute in Georgia. And generally, by the way, I'm going to be focusing on Georgia law in this talk because the nonprofits that Pro Bono Partnership serves are based in Georgia. Generally, for most of the issues we're talking about, most large states that you might see in a contract a provision that their law controls, for example, New York or Illinois law you often see. And most of these issues, their law will be substantially the same, but there might be some differences in specific areas. Anyway, in Georgia, there are some exceptions. The contracts must be in writing to be enforced. I've called out the ones that might be relevant to you all here, and those are that an agreement regarding the sale of real estate real property or an interest in real property generally must be in writing. An agreement to sell more than $500 in goods must be in writing to be enforced. Promises to make a loan must be in writing, and promises to pay another's debt, pay a loan for them, must be in writing. And promises that cannot be performed within 1 year generally must be in writing. Now, if you've had experience with the legal system in Georgia or the laws in general, you know that there are very few hard and fast rules, and there are exceptions to these exceptions. For example, if the other side substantially performs the oral agreement, even though generally it must be in writing, a court may require you to honor that agreement. For example, if you have a contract that you sublet a farm to a tenant and say if they will harvest the crops and maintain the property for 20 years, and you'll split the proceeds of selling the crops, and at the end of the 20 years, you'll turn over the property to them, and at the year 19, you decide, you get an offer that's too good to refuse. The court may say, well, you're stuck with that promise even though it was not in writing because the tenant performed for 19 of the 20 years. That's called estoppel. A related issue is that you don't have to necessarily have a writing that both parties sign. A common example for you would be invoices. Often you'll get invoiced by a supplier of office equipment or copy paper, and that can be a valid agreement. We'll talk more about that later, even though both parties haven't signed it. And if you do have a written agreement, it doesn't have to be multiple pages. An agreement can be one sentence, and if it lays out the promise, specifically what's going to be done and who the parties are, there's an agreement, it can be enforced. One general topic I wanted to go over is what are the general remedies if the contract is breached, if the promise is broken. Generally, there are two remedies. The aggrieved party can seek in court monetary damages for the breach, or in some circumstances, an order from the court that the promise be fulfilled, that the contract be performed. That's called in Georgia a request for specific performance of the contract. That latter remedy is only generally available if it's a unique contract, such as the sale of a particular piece of land. If the court finds that monetary damage will compensate the aggrieved party, then generally the aggrieved party cannot get that order for specific performance. Monetary damages can take some different forms. The most common form is an award for lost profits, what you would have earned if the contract had been performed. Sometimes you have a hard time proving those. Sometimes you can only get the costs you incurred in relying on the other side to perform the contract. Get attorneys. question of getting attorney's fees. The only other circumstances, generally we're having some technical difficulties, so we may pause from time to time, but the only other situation generally in which you can get attorney's fees in Georgia, the only other scenario is if the other side has acted in bad faith in the transaction. Maybe they have misrepresented a fact in getting you to either agree to the contract or perform the contract. Or once the dispute arose, once it went to court, they engaged in contact that the law calls stubborn litigiousness, or putting you to unnecessary burden or expense. As a practical matter, what that means is, well, let me give an example to show what it means. Maybe the other side has denied throughout the litigation a fact that's obviously true, and once you establish that fact, the court may find that the other side was stubborn and litigious and allow you to get attorney's fees. But in the run-of-the-mill contract dispute, the prevailing party does not get attorney's fees. Now, what should you do if you perceive a breach of your contract has been breached, the other side is not keeping their promise? To start at the bottom of this list, first and foremost, you should consult an attorney. And again, if you cannot afford an attorney, talk to a pro bono partnership. We may be able to provide an attorney either to consult or to represent you throughout the dispute. Save your records, and the attorney would talk to you about that, but save your records, not only the contract, but correspondence with the other side, internal emails about the contract, the matter, records of payment, that kind of thing. Be polite, of course. I'm a firm believer in always being professional, regardless of whether the other side is polite or professional. But be firm. One of the biggest mistakes I see, and we'll talk more about this, is when a party to an agreement is reluctant to, take the steps to tell the other side, I think you breached the agreement. People like to avoid unpleasant tasks, but particularly in contracting, a lot of times it may be a supplier that you've worked with for a decade, an employee that's worked with you for a decade that you've become good friends with, etc. But you have to assert your rights. The practical problem, if you don't, is that you may be found by the court to have waived your ability to claim a breach of the agreement, or you may be found to have waived certain remedies. A related doctrine in Georgia is that you're stopped from asserting a breach of contract depending on whether the other side relied on your inaction, your failure to assert the breach. There's a specific related doctrine in Georgia called the mutual departure doctrine. It's a statutory provision in the contracts code in Georgia. And what that generally provides is if you have a contract and both parties depart from the specific terms of the contract and something of value is given, money's paid, work is done, under that departure, you have to give reasonable notice to return to the original terms of the agreement, and you have to give the other side a reasonable time to return. For example, if again you sublet your office space to a subtenant and the agreement says the subtenant will pay rent every month on the 5th day of the month, but for 2 years you've accepted the rent on the 30th day of the month, you can't all of a sudden claim the subtenant breached the agreement by not paying on the 5th day. If you want to return to that requirement, you've got to give the tenant notice and a reasonable time to go back to what the contract originally said. What to do if you are accused of breaching a contract, breaking your promise. Again, first and foremost, consult an attorney and retain your relevant records. And by the way, these days and for a long time, this has included emails, internal emails, and other electronic files about the matter. Not just the contract, but the work done related to the contract. So you need to keep those kind of records. Once you know there is a dispute pending about, a dispute in prospect about the agreement. Again, when you are accused, it's very important as a general rule to respond to the allegations. Again, painful as that may be, upsetting to a relationship as it may be, um, silence, failure to respond to allegations that you've breached the agreement can be deemed an admission and acquiescence in the allegations. And that's for a couple of reasons or under a couple of principles. First, in Georgia, this is under the evidence code, not the contract code, but there's a specific provision that says in a business relationship, if you receive a letter that a reasonable person would respond to, in this case, denying allegations that you breached an agreement, and you do not, the jury or the judge can find that they can, there's a presumption that they can travel on, the judge or the jury, that you agree with the allegations, you don't deny them. And even without that statutory provision, as a practical matter, if this dispute does go to court, then the judge and the jury is going to look back at the history of the relationship, and if they see there was a letter months before the lawsuit was filed where the other side asserted that you breached the agreement and you did not respond, as a practical matter, the judge or jury may conclude, well, there must have been something to that allegation, or you, in this case, the receiving party, would have responded. Again, be professional, polite. The response should be factual. As a general rule, again, I would generally avoid going into chapter and verse and writing a novel, but you should lay out the basic facts. Be sure the facts, of course, are accurate and supportable, but you should, as a general rule, respond to such charges. The old proverb, a stitch in time saves nine. I've seen repeatedly, I've probably litigated certainly more than a couple of hundred contract disputes of various kinds, and it's very true that taking action early can avoid a much bigger problem down the line. I want to take a few minutes to talk about some contract issues that I think might be specific to nonprofits and really any business doing, for-profit or nonprofit business providing services. One relates to employment, the various employment issues. As a general rule, when you provide benefits, salary, other benefits, it's good to put those benefits in writing so there's no misunderstanding. And it's very good as the employer to put the employment, the nature of the employment relationship in writing. If you're going to review this, if this is an annual contract, you should put that in writing. If they're an employee, Georgia allows at-will employment where the employer, subject of course to anti-discrimination statutes and those kinds of things, can terminate someone's employment without any reason. That flexibility is valued by employers, and so, but you need to put that in writing. Again, you may hire someone you know very well, you have a long-term relationship, but if things go south, if their financial status changes, their attitude may change, and frankly, again, from litigating hundreds of such disputes, their memory may change. That's one of the surprising things to me in my 30 years of practice, is how many times the institutional memory of businesses and the memory of individuals changes depending on where they're sitting in a particular dispute. Or, you may have a contract with a business or an employee. The employee may pass away, the business may go out of business or be sold, you're dealing with a new owner, and they may not know what the discussions were years ago when this relationship started. They're going to look at the written record and they're going to assert what rights they believe they're entitled to. In that regard, another specific contract issue that relates to profit and nonprofit businesses deals with purchase orders and invoices. The law wants to facilitate business without trying to minimize the paperwork particularly between two businesses. For example, again, if you're buying office equipment or copy paper, or you're getting someone to enter into a contract to service your website or computer system. You don't have to have an overall written agreement. One thing that can happen is you can send in an order for office equipment. The supplier may send you back an invoice that says, fine, we'll provide this equipment. We're going to deliver it in 30 days. Here are the terms. And all those terms, including the fine print on the back of the invoice that the supplier sent back to you, may govern the relationship under the law, even if they differ from the order that you initially sent. So you need to look at the small print or take the risk that you're going to be subject to terms that you didn't realize were there. Another thing we commonly actually advise clients about, including nonprofits, deal with the ownership of written work product. We represent some trade associations and some nonprofits that advise businesses and trade associations who create, for example, policy manuals, standards, industry standards, trade standards, or standards manuals. And for example, we have clients where they want all the members of the trade association to be able to use the manuals, but they want to control, for quality reasons primarily, the contents of the manuals. So it's very important to put in writing what rights the trade association members have don't have in regard to modifying the manuals. Similarly, when you create the manuals, it's very important to put in writing who's going to own the work product, both with your employees, although frankly it's a bigger issue if you have a contractor or consultant that you hire for that specific project of creating the manual, but they're not your employee. You should document who you're going to own. You're paying for the work product and you own it. Particularly in the case of a contractor or consultant, if you don't do that, you may end up with a situation where you own it jointly with the contractor, where you can use it, but also the contractor can use it, can license it, can modify it. That's, in our experience, not the situation that nonprofits want when they're trying to promulgate industry or trade standards. Let me talk about some overall general do's and don'ts in contracting, not specific to any kind of contract. First and foremost, first one is know who you're doing business with. It's very easy, you probably know this, how much information you can find out with a simple internet search when you're about to sign a contract with a supplier, or particularly with a consultant who's going to maybe develop your website or draft your manual. You can look up any prior complaints, prior businesses. You can look up prior lawsuits. I had a personal situation, an anecdote relevant to this, where we suffered through a house fire and had to rebuild a portion of the house. And the insurance adjuster initially gave me a recommendation of a contractor who they had dealt with. And I looked at the lawsuits and provided the insurance adjuster with literally a 1-inch thick list of lawsuits the contractor had been involved with. It must have been every single job the contractor had ever done because it was so voluminous. And needless to say, the insurance adjuster backed off that recommendation. Related to that, be sure, particularly when you're doing a written agreement, you have the proper name of the parties, the role in the agreement. Because if the cart gets in the ditch and there's a dispute and it's uncertain or unclear, the other side may try to take advantage of that. Read the agreement in full. Again, try to consult with an attorney if it's a significant contract. Read the agreement in full. Be sure you understand all of the terms. If you use terms of art or industry terms, be sure they're defined. Again, you may think you and the other side have the same understanding at the onset of the relationship, but people's understandings may change. They may legitimately forget, or again, a new owner may come into the business and have a different understanding, or once a dispute arises, want to advocate a different understanding. And if the term is not defined in the agreement, they may have that leeway. and use plain English in general and definite terms. Avoid ambiguous terms. Um, there's litigation in any situation. If you're paying an attorney, it's costly. There's a great New Yorker cartoon of an attorney in her wood-paneled office, and she says to the client, "You have a great claim now. How much justice can you afford?" And so it's expensive anyway. It's time-consuming. There's a lot of emotional involvement and emotional cost in litigating a dispute. And you certainly don't want your attorney spending time having to debate over a term that you thought was clear or under. Everybody knew what it meant. And there's a positive aspect to this as well. Georgia in general, the legal principle is Georgia enforces contracts, and Georgia expects the contracting parties to exercise due diligence, read the contract again, and make sure with the consideration again, as I said at the start, courts will not second guess whether the value given for the agreement is adequate. They expect the parties to make that decision and live with it. And consistent with that, if a dispute does go to court, the first place the judge is going to look in interpreting the contract is the four corners of the agreement if it's in writing. And if the judge finds the contract is clear, he or she is not going to allow either party to put in other evidence about, well, I know it says X in the written agreement, but we really intended it to be Y. That's called the parole evidence rule. And again, it's consistent with the principle that you need to look at the contract, make sure you understand it, and once you sign it or agree to it, you live with it. If, however, the judge finds that the contract is ambiguous or unclear, then after taking some other steps, the judge will allow, in general, evidence about what the prior negotiations were, what the correspondence was. And again, that makes the litigation more time-consuming, more costly, and the result less certain. So I've seen this. That's the biggest practical recommendation I think I can make today, other than consulting an attorney, is use plain English and make sure your terms are clear and definite. Consider thinking of disputes, the potential for disputes in the future. Consider requiring in your agreement a provision that requires notice if the other side deems the contract has been breached and you haven't performed your obligation, with a right to cure. Typically, there's a provision when these terms are included that the other side has to give you written notice at a specified address and give you some time, often 30 days, to cure the breach before they can go to court and assert that the contract has been breached. If that provision is there, again, as I said, they may say you haven't performed, but until they give you the right to cure, there is no legal breach, so they can't legally go to court. And you don't want to have a situation where the minute a dispute arises, the other side's unhappy. You want to avoid the situation where they're rushing to court immediately and starting the litigation process. Some parties even include a provision that there will be a negotiation before there's a lawsuit. Some are often now asserting even provisions for mediation, which is basically a negotiation with a third party to come in and facilitate the negotiation. And of course, some parties assert or include provisions that if you can't resolve it by agreement, then you'll specify what the resolution will be, either or the means for resolving the dispute, either an arbitration, or sometimes both parties agree we'll go to this court to conduct the litigation. Consider if the contract has any significance. Should there be limits of liability? Georgia will enforce certain limits of liability. Either types of damages can be excluded, or certain conduct can be agreed that there won't be damages for sometimes simple negligence, for example. consider whether you should require the other side to provide insurance. For example, if they're renovating your office space, if they are engaging in a long-term contract to maintain your computer system or your website, you may want to consider a requirement that they have insurance. And if you do have that requirement, if you do include it, it is common to also include the requirement that they provide proof to you that they have the required insurance. Finally, some general don'ts in regard to contracts. Some of these are simply the flip side of the general do's, beginning with don't agree to ambiguous language. If you don't understand what it means, you need to try to clarify it and revise that contract language before you sign it. And consistent with that, do not accept the other side's interpretation of a term that to you is unclear. Because again, you could have an email exchange about what a term means, and then you sign the contract, but unless the judge then, if there's a dispute, if the judge finds it to him or her that term is not unclear, the judge is not going to consider, again, evidence of what the email exchange was before the contract was signed about the meaning. So be sure that don't accept the other side's interpretation. Oh, well, this means, everybody knows what this means. It won't be a problem. Don't accept that kind of assurances. Try to avoid redundant terms or provisions in the contract. I've seen this a surprising number of times where people think that, well, the contract provision is particularly important, so it must help if I put it in the contract more than once. Under the law, the judge is to enforce every term of the agreement, and some terms are obviously important. And the practical problem with including a redundant term or provision is primarily, there's a couple of things, but the primary one I want to mention is that unless you describe it in exactly the same way, if the language varies, then that gives the other side room to argue that the term or provision means something other than what you thought it meant. It's consistent with, again, avoiding unclear terms. You would be surprised how much time and energy and expense goes into litigating the meaning of single terms or even single words in a contract, the placement of a comma, etc. Don't sign agreements. This is another significant practical pointer. Do not sign agreements with blank terms or missing parts. A lot of times in agreements, for example, I've litigated a lot of software support contracts and software licenses, and in those agreements, a lot of the meat of the agreement is in an addendum or attachment. It's called various things: attachment, addendum, exhibit. And sometimes, again, you've negotiated a contract for a long time. You need to get the system in place. You trust the other side. And they say, well, if you need it, let's just sign this. You know what the system's going to be. We'll send you the addendum next week. You sign it. The addendum comes. You don't read it. You put it in the file. Lo and behold, it says something different than what you intended, or frankly, what you agreed to. That has happened for innocent reasons. Or sometimes, the addendum's never sent, and you just continue down this path, and then a dispute arises, and you don't have the attachment. So, if you can, insist on the blank terms be filled in, that the addenda be provided, the exhibits be provided. So, again, you know what you're signing. So that concludes my practical pointers about the do's and don'ts of contracting. If you have any questions, I'd be glad to answer. right, seems that we have a few questions we think are coming, so we'll wait a minute. I'll try to address them. Right, a pro bono partnership. You can certainly talk to a pro bono partnership about that kind of service. I think pro bono partnership provides that on a regular basis, and that raises a very good question. That it is a very good question. It raises a point. It is good to review your contracts, particularly as you get to a significant size where maybe you have multiple supply contracts or multiple employee contracts with employees. The law does change. Georgia recently changed, for example, the law about non-competes to generally make them more easy to enforce than they used to be. So it's good to review your contracts annually and, make sure that the provisions that you think are good law are still good law. The next question is related to prepare memoranda of understanding for nonprofits. Yes. There was a question about whether pro bono partnership prepares memoranda of understanding for nonprofits, and yes, pro bono partnership on a regular basis does provide or help draft both memoranda of understanding or the actual contracts for the nonprofit clients. When a contract is signed, do all pages have to be initialed? The question was, when a contract is signed, do all pages have to be initialed? The answer is no. It's certainly sufficient if both parties sign. In fact, again, consistent with what I said at the beginning, you can have situations where you have the written agreement and no party signed it, but it ends up being an enforceable contract because you started performing it, etc., or one party signed. Then in those cases, there may be a dispute about do the terms of that written contract govern because both parties didn't sign it, or were there some other oral term. But to go back to the initial question, to legally enforce it, you do not have to have each page initialed. But a lot of people are now recommending that you have both parties initial every page because in this day when you can change pages on the computer fairly easily, and sometimes contracts are stored electronically, and you are seeing more and more cases. It used to be you never hardly ever saw this, but you are seeing cases now where the party that's, as a general trying to escape the obligation is saying that some page was modified, and therefore the contract is not enforceable against them. So a lot of people are now recommending that you initial each page. A related point is, and I've always done this, sometimes you'll have a written agreement and then you will make at the last minute, well, either you had some final tweak to the terms or the contract didn't accurately state the terms, so you'll make, when you get together, a handwritten change to the contract. I would recommend you have both parties initial that handwritten change. So again, there's no argument that, well, I signed the typed contract and then they went back and made that handwritten change. We have another question about the enforceability of written agreements, and the individual asks whether a written agreement and handwriting on something like a NAFTA would be enforceable. Yeah, their question was whether a written agreement that is in handwriting on a napkin can be enforced. Yes, it can in two different ways. First, you can sign a handwritten agreement, even a napkin or a piece of paper, and that can be an enforceable agreement. Second, you can have a situation where what the parties wrote on the napkin is not And as we talked about at the start, absent the certain exceptions that Georgia law has, uh, oral agreements can be enforced. Um, and then they can cite to that napkin as evidence, some evidence of what the terms were being discussed at the time, even if it's not the entire outstanding case for the band, the Black Crows, where someone who used to be in management, there was, in fact, a napkin, and there was a pie, and there was a division of the proceeds. What they said was, what the plaintiff said was a pie chart to divide the proceeds from the upcoming album, even though my recollection, I wasn't involved in this, but my recollection was that napkin didn't specify that. But that went all the way through trial, that case. All right, well, thank you, and have a good day.